Chair recognizes the gentleman from Bullock 26 for explanation of the bill and a motion thereon.
Thank you, Mr. Speaker. We have before us Senate Bill 5. This bill gives the greatest level of control to parents, principals, and school boards in our Commonwealth. I want to begin by individuals that are looking at the bill would look at Section 1, and there we have the definitions that outline what we would be talking about as material that is harmful to minors. I want individuals to take special note of item number B. It says, taken as a whole, appeal to the prurient interest in sex. That should be thought of as an extreme interest in sex, and that has been defined by the courts. We also have in Kentucky statute definitions of obscenity, and the federal courts and courts across the land have ruled on the issue of obscenity. With those in mind, I'm now going to move through the various portions of the bill to kind of give us an outline. So we have a section here that adopts a complaint policy for parents to file with the principal of a school if they've determined that there is material there that they find meets these guidelines for their children. And they would submit to a principal in writing a detailed description of the complaint they have about whether it's reading material or whether it's an event or a program in the school. The principal would then have 7 days, business days, to review the material, and then after 7 days or within a determined time period that is agreeable with the parents, he would release a determination if the material is harmful. And within 10 days of the initial date of the complaint, the principal would have to inform the parents if he determined that the material met the guidelines for being inappropriate or did not meet the guidelines. In the event that the principal would determine that the material did not meet the guidelines, there would be an appeal process. Those parents would be allowed to appeal the decision directly to the school board. That decision, the decision when appealed to the school board, could not be delegated to anyone else. It would have to be handled by the members of the school board. There would be opportunity for public input that must be completed in 30 calendar days of the written appeal, and it must be discussed and voted on in a public setting. Members of the school board would be on record individually as how they voted on that decision. And final disposition must be made in writing to the public, and within 15 days of the final disposition, it must be published on the board website or published in the newspaper with the greatest circulation in that community. If the parental appeal is determined to not be successful in the parents, then that material would remain in the school system. If it did remain there, parents would have the option of instructing the school system to make sure that their children were not made available to the material or to the event or to the program. The bill does have an emergency clause, and it does have a section here that says that no later than May 1st of 2023, the Department of Education shall promulgate a model policy for complaint resolution process that meets the requirements of subsections 2, 3, and 4 of this section. As I said earlier, this particular bill right here is in response to parents in the Commonwealth who want an opportunity to object to material that they consider to be inappropriate. That's material, that's events, that's programs that they determine is inappropriate for their children. And the guideline for outlining this that the principal must take and eventually the school board must take is going to be based upon court precedent that has been set, court decisions that have been determined in the past. So there is firm legal foundation for this. You may hear that this is book banning. This is not a book banning bill. This is a bill designed to give parents an opportunity to voice their concerns and to protect their children. Mr. Speaker, At this time, I now move for the passage of Senate Bill 5.